Hi, it's 3:05, so let's go ahead and get back to the program. My name is Colleen Chien, and I'm a professor at Berkeley Law. For 15 years, I was teaching at Santa Clara Law, so it's nice to see a lot of familiar faces. I'm just in a new setting now. It's great to be joining this very rich conversation and turn to this question of what beyond inventorship do we really need to be thinking about with respect to the interface of AI-assisted inventions and patent law. So I know our time is short. I want to jump right into it. I want to introduce two new speakers to our colloquy today. First, Professor Peter Lee, Martin Luther King Jr. Professor of Law, and the director of the brand new Center for Innovation Law and Society at UC Davis. And he'll be talking about his work and how it now, as alluded to earlier, on transactions and on thinking about how IP can be used to create and support new businesses, how he sees now IP doctrine and patent doctrine really interfacing with AI. And then we're lucky to have Dr. Ali, another doctor, just like Dr. Howe, both a JD and a PhD, Dr. Ali Alemozafar, who's a partner at Wilson Sonsini and Goodrich and Rosati, and he focuses on strategic IP counseling. He has degrees from Harvard, Stanford, and Cornell, or at least he did a postdoc at Harvard and got his JD at the University of California Law, San Francisco. So I'm going to turn over to Professor Lee to kick us off and talk a little bit about beyond inventorship, what types of topics you're encountering in your work that you think are important for us to pay attention to.
Okay, great. Well, thank you very much for having me. I'm going to take a moment to get my slides up. Here we go. So does that look okay? Yes?
Yes.
Okay, great. So I'm going to talk for a bit about AI as an inventing tool, intersections with novelty, non-obviousness, and disclosure. So, our theme of the day is AI as an inventing tool. That raises some questions. What is entailed in invention, and how can AI help? And so AI can perform a number of functions. It can, in theory, contribute to the conception of a new invention, even reduction of practice. But sometimes invention begins with simply searching the prior art. So this could lead to substantive learning. Perhaps you want to obtain some training data for your AI model. This can also help ensure the patentability of any resulting invention. And there are a number of AI tools available to help search the prior art, such as PQAI, PatSnap, CAS, STNext, and others. And I'll mention as well that on the other side, the PTO is also using AI to search prior art during examinations. It's already conducted over 1.3 million searches using AI tools. All right, so this discussion of prior art leads to considerations of novelty, and there are some concerns that AI will lead to a proliferation of prior art, thus making novelty more difficult to satisfy. So as I mentioned, AI tools are available to find prior art. Users of generative AI may unwittingly create more prior art, and there's even AI that deliberately creates prior art with the express purpose of defeating patents. So for instance, all prior art is a project aimed at algorithmically creating and publicly publishing all possible new prior art, thereby making the published concepts not patentable. So this seems kind of dire. But I think that these concerns are a bit overblown, and there are legal considerations pushing against the AI-based proliferation of prior art. So there are, of course, the traditional statutory and doctrinal definitions of prior art. So in general, prior art must be public. So most relevant for our purposes, we're talking about references described in a printed publication or otherwise available to the public. And so, for instance, inventions stored in DeepMind's corporate databases are likely not prior art. They're likely not kind of publicly accessible in any meaningful way. There's also an identity standard for anticipation. So there must be a single prior art reference that has every element of a claimed invention in order to anticipate. And there's, of course, an enablement standard for anticipation. So for instance, an AI-generated image or brief description of an invention may not be an enabling prior art reference. So I actually went on a generative AI site. I asked it to create a synthetic protein. It came up with this. I have no idea if this actually does anything, but I know this is not an enabling prior art reference. This image does not teach the FOSITA how to practice this invention. All right, so turning to non-obviousness, I think AI is likely to make non-obviousness more difficult to satisfy. And we can examine this through the lens of the Graham framework for non-obviousness. So there are three primary factual inquiries, the first of which is the scope and content of the prior art. So with AI, we might have more prior art, certainly more accessible prior art. And we know the FOSITA is charged with knowledge of all pertinent prior art. So probably not very realistic, but this becomes more realistic with AI. So one implication I think we might see is a narrowing or elimination even of the analogous arts limitation. So pertinent prior art here refers to prior art from the same field of endeavor, or that is reasonably pertinent to a particular technical problem. With ML pattern recognition, we're expanding the set of pertinent prior art, so we might see some narrowing in this analogous arts limitation. All right, so the second prong of the Graham framework has to do with the differences between the prior art and the claims at issue. Arguably, AI increases the gap between the prior art and the claims needed to satisfy non-obviousness. To the extent that we have expansive inventive capacity, some additional quantum of advancement might be necessary to satisfy that non-obviousness threshold. And finally, much of the debate is focused on the level of ordinary skill in the art. And so courts traditionally consider things like the types of problems in the field, prior art solutions, the rapidity of innovation, and the sophistication of technology. And there have been a number of suggestions for modifying the level of ordinary skill analysis. So some want to retain a human-centered standard, which would focus on a person having ordinary skill in AI. But here the skill is not traditional inventing skill per se, but the skill might refer to the user's framing of the problem, the selection and control of ML and data, and any adjustments. So there's an intermediate approach, which I think is most likely, which focuses on humans augmented by AI. So the FOSITA facilitated by, extended by AI. We see an analogy to FOSITAs using search engines, right? So this certainly in some ways raises a level of skill in the art. And finally, at the far end of the spectrum, there's an AI-centered approach where courts could consider the AI skill in the art or the inventive machine standard. I don't think courts are quite there yet. All right, so the final element of the Graham framework are, of course, secondary considerations, factors like commercial success, satisfaction of long-felt needs, failure of others. I think these may increase in importance with AI-assisted invention. So consider that you're a district court judge. You have to determine non-obviousness. You don't really understand the technology. You may not understand AI. You might want to know, is this invention very commercially successful? So here we're kind of adopting an economic or pragmatic approach to non-obviousness as opposed to a purely cognitive one. If you consider what AlphaFold achieved, right? So they solved a huge problem in biology. They won a number of awards. These objective indications of non-obviousness would certainly weigh in their favor. All right, so I think it's kind of interesting to consider AI and obvious to try. This actually was a question that arose in the first panel. So in 2006, the Supreme Court ruled that obvious to try may in some circumstances actually indicate obviousness. And so trying a finite number of predictable solutions with a reasonable expectation of success is likely obvious. That being said, the Federal Circuit has clarified or confirmed that some obvious to try inventions are still non-obvious, such as when you vary all parameters where the prior art provides no guidance or direction. So how someone frames a problem or selects a model may be non-obvious. Additionally, this may arise where one explores a new technology where the prior art gives only general guidance regarding the form of the claimed invention. So the upshot is that some AI-assisted inventions may be obvious to try, yet non-obvious. All right, so turning to disclosure, enablement and written description are also measured relative to the FOSITA, all things being equal. If the level of ordinary skill increases, it's harder to establish non-obviousness, but easier to enable and describe, right? So there's a wider knowledge base from which the FOSITA is drawing. I think it's important to draw a distinction between AI-assisted inventions that do not themselves incorporate an AI model and those that do. So focusing on the first set of inventions, so these are AI-assisted inventions not requiring disclosure of an AI model. Consider the invention that Dabis purportedly created, a food or beverage container comprising a generally cylindrical wall defining an internal chamber of the container. Then it goes on from there. We're talking basically about a water bottle. There is some fractal geometry involved, but there's no AI model in the actual invention itself and no particular disclosure challenges. On the other hand, we might have some AI-assisted inventions that actually do incorporate an AI model. So for instance, we have DeepMind, who has an invention called machine learning for determining protein structures. And it claims a method performed by one or more data processing apparatus for determining a final predicted structure of a given protein. So here the model is actually kind of at the heart of the invention itself, and disclosure is more difficult to satisfy, but it's not impossible to do so. Now, there are concerns over the black box nature of ML models. Allegedly, this makes them very difficult to disclose, but disclosure can be achieved through including algorithms, flowcharts, training data, and training procedures. And some have even suggested depositing the model and training data for public accessibility. All right, so finally, I want to end with some theoretical considerations. It actually goes back to some of the comments that Rob was making in the previous panel. Why do we grant patents? We have this inducement theory of patentability. We should only grant patents on inventions that would not arise or would not arise as quickly without patents. But if AI can invent technologies very easily, this kind of pokes some holes in that inducement theory. So what are patents actually incentivizing? Well, traditionally, they're incentivizing invention, but in a post-AI world, perhaps they're really incentivizing ex-ante problem identification, the selection of parameters for models, the selection of data. Invention becomes a relatively trivial exercise, but they're also incentivizing ex-post development and commercialization. So with that, I'll close, and I look forward to the rest of our discussion.
Thanks, Professor Lee. I think one question, having read a lot of your work around kind of commercialization and contract theory, I mean, in terms of patents and their usefulness in transactional context, like what are your thoughts around, AI's impact with respect to making sure that, like, if it's true that patent bar becomes a little higher because the FOSITA is that much more, can do that many more things, do you think that's going to really impact the ability for firms to interact with each other and transact over technology? Or are there other ways, if we don't have patents, we start transacting for trade secrets, that we can still continue to make these deals?
Right, so it's a good question. I think that there are multiple mechanisms available. And so you mentioned trade secrets, so people can still transact around trade secrets. There are some advantages to patents, and I think as Rob has written about, patents lower the cost of transactions in the realm of technology. And so this kind of goes to the tail end of my comments and kind of almost a commercialization rationale for patents, right? So the act of invention becomes very easy. We still may want patents to facilitate commercialization, and part of facilitating commercialization is transactions. And so, I think that Dr. Howe mentioned this as well in one of her remarks, but the patent license doesn't have to, or the patent itself doesn't have to disclose all the relevant information. The patent license becomes a bridge or a scaffold around which a broader relationship can grow. And so I think there's still going to be a very valuable role for patents in facilitating transactions and commercialization.
Great. Well, we're going to turn over to Dr. Alemozafar, Ali, if you're here, and we want to try to get into a question of your clients as they're patenting their inventions. Before you even talk about the inventing themselves, are you seeing any shifts in why they're patenting or how important patents are in light of the current ecosystem? I think one thing that's been just remarkable from an IP perspective is how these large LLMs have really been developed based on an open type of ecosystem in terms of information, right? The original GPT paper came out of Google, but was out open sourced. It wasn't patented. So it created the ability for the generative pre-trained transformer model to emerge, which then companies have adopted. And you have open models where people are kind of giving away their GPT infrastructure, and then others that are closed. But you have a lot of innovation, a lot of rapid development. It doesn't seem like anybody's really that concerned about IP. But you work with companies that are going to be spending billions and investing on making sure that they can get that exclusivity. So can you talk a little bit about the strategy, and then also answer these questions about, sort of beyond inventorship, things that are coming up for you?
Of course, Colleen, and thank you for having me. We've been working with machine learning innovations, specifically in the life sciences for years. Actually, it's just going back several years to patents that I helped to secure in the diagnostic space around using ML to classify markers A, B, and C for disease W. And there, the innovation was of course critical to what was happening, and patent coverage was also obtained with the balance. And this is something that that when I speak about my sort of various topics, I'll touch on, which is striking a balance between what to patent and what to keep as a trade secret when it comes to ML. But right now, with the latest wave of machine learning innovations, we're seeing companies are protecting ML at various levels. First and foremost is in the life sciences, when you have discovery tools, discovery platforms that are outputting protein X for indication Y and whatnot, which are then run through clinical trials. Those are being patented. So whatever comes out of ML, there's a heavy emphasis towards patents in the therapeutic space, somewhat patent 101 in that space. The discovery platform itself is also being potentially patented. So there is also angles around that. And separately is different types of ML algorithms. We are helping companies to secure patent coverage around those as well.
Let me ask two questions related to that. And I think, there's a lot of concern, or there continues to be a lot of concern about 101 and Mayo and its impact on the ability to get diagnostic patents. I think with Vanda and thinking about, ways of you can still get patents, but they're narrower. So are you finding that your companies are less able to kind of do what they need to do with these narrow patents, or have they kind of adopted and adjusted to the kind of the new norm? So that's one question. And then I think, when you talked about ML being around for a long time, I think there's a sense of, is it just going to be about people taking the existing sort of approaches and then say plus ML, and we want to get a patent on that? I mean, is that one of the strategies, do you think, that's predominant in your companies that are coming to you, that they're really trying to patent as much as they can with the ML plus Gen AI addition?
Yeah. So taking things in turn. First is the Section 101 issue, Alice. What that ultimately amounts to is the addition of a step of treating. So if we're going to be playing the Vanda play, and of course there is issues of divided infringement, which we are mindful about, but largely in the diagnostic space, that's a non-issue in view of the latest standard there, because there's usually some sort of relationship between the person who is ordering the test and the person who is ultimately providing the treatment. So it hasn't chilled innovation, hasn't chilled patent filing. It's just been it's come down to adapting to the latest standard, if you will. And then separately is when it comes to and then I will talk more about these Section 101 issues when I go through my slides as well. And then the other topic, sorry, if you don't mind repeating your second question.
Oh, it's just about sort of the idea of adding machine learning or adding generative AI to sort of existing approaches, and whether or not that's enough.
Of course, and there are companies that are doing that, but to prepare the machine learning platform requires use of a highly curated set of training sets of data. It's not as simple as you just take this off-the-shelf ML model and then just hit go. You have to spend a long time to pick the right data, to train it in just the right way to give you the right outputs. And companies spend lots of dollars and time to pick the right data set. And so we're seeing a lot of work also on methods of treating ML to yield a specially trained machine learning model / platform.
I think Professor Murgis and Dr. Howe will have a lot to ask and say about that, especially thinking about sweat of the brow versus conception versus, what exactly are we trying to incent? But did you want to share some slides? And then we'll turn over to Professor Murgis after that to take it.
Absolutely, sure. I'm going to test my computer skills here to share my screen. I'm glad that Peter passed that test, so I'm going to see if I can pass the test too. Okay, share screen. Do you all see my screen?
Yes, thank you.
Absolutely. I'm going to slide presentation mode. Do you still see it?
Uh-huh.
Great. So I'm going to quickly go through this for the members here. And some of this has been touched on before, so I'll just go through this fairly quickly. In my practice, when it comes to helping to protect machine learning innovations / AI, what I'm seeing frequently is getting patent coverage around the actual ML itself. Is there a new algorithm that's being used, a new type of CNN, even a use of a known algorithm, but using a special set of data to train it. So ways of training ML, and of course, it's the applications of the ML. I do tons of work in the life science space, and there we see work on both the therapeutic side as well as the diagnostic side of uses of ML for something. And these have done fantastic magic and wonderful things to companies that are trying to help to protect and to provide people that are in need of help in the life science side of things. And then we get down to what the ML outputs. So a very common example is a discovery platform, which is being used to identify a therapeutic. We've helped companies to patent ways of generating a discovery tool to identify a therapeutic target, a drug, and of course, those are patented. But then we've also helped companies to protect the actual platform itself. Tends to be fairly rare because what happens more commonly for companies that have a discovery tool is to keep the tool itself as a trade secret, as a black box. The thinking is this: if you even have a patent that covers your tool and someone out there is using it, can you prove that they are using it to go out there and stop them? So there are challenges with proving that someone is using the patented tool, which is why the rule for discovery tools tends to be to keep the ML as a trade secret and to patent what comes out of it. But there are exceptions if, for instance, the tool may be used widely, if there is risk of disclosure publicly, and so on, then we may lean more heavily towards patents. And I've touched on the trade secret angle. But when we play the game of patenting the ML, we also look for ways of keeping the specifics of the machine learning as a trade secret. That's like things like the weights, scaling factors that you are giving to various features that are being identified. Very commonly, those are kept as a trade secret because they're too specific for patents. And that's on the trade secret side. Moving fairly quickly here. So hurdles to getting a patent that I've seen continue to be here. We still see issues under Section 101, but that has largely become fairly streamlined. The Patent Office, in my view, has done a fantastic job at trying to streamline the whole process. Examiners have been trained. There are guidelines that have been passed down post-Vanda and so on. And what we see is, for instance, if you have a machine learning claim set that is around the actual model itself or ways of training or even using it, whenever a judicial exception is implicated, you get this Section 101 rejection. And the ways to get past it are either basically under ALSEP 2A prong 2, as you show that the JE is integrated into a practical application, which is you show that there is some sort of improvement to a technology or a treating step. And or you find ways to show that the claimed features are somewhat not routine or conventional. That's under ALSEP 2B.
Specifically on that one, though, with respect to AI and ML, what does that actually translate into? Do you need to talk about unconventional applications or unconventional steps and actually how you were, you know, in the claim itself? I'm just, interested in.
It's the actual model itself. If
Okay.
there's something about the model that is not routine or conventional, like we have actually patented very special models, and this kind of goes hand in hand with section 102/103, because when you show that your claimed invention has features that are not routine or conventional, you're also sort of saying that this is new, is very special, and so it's something special about the model itself that, as far as we know, and as far as the art shows, has never been done before.
Thank you.
Great, fantastic question there. This is what Peter touched on: is the prior art sort of calculus stays the same. If we are trying to patent a new model or use of a trained machine learning model for something, that of course has to be new and has to also be not obvious. And then we get down to which is something that's somewhat tricky, is section 112, which is how much of the actual model do you disclose to meet the 112 standard without giving away too much. And that is, I suspect, is going to become a bigger problem. And companies may try to heavily use the best of both worlds, which is patenting the model itself at a higher level while keeping the specifics as a trade secret. But ultimately, the specifics may become more important as we find ways to differentiate from the art, because this is largely becoming a super crowded space rapidly. And so I suspect that we may have to provide more disclosure to have ways of differentiating from the art out there.
Oh, interesting. So you're saying it's a crowded space, people are patenting a lot, so you're going to claim more narrowly, and then you need to have more in terms of disclosure to support that?
Exactly.
Okay, and you have a question from Professor Sarnoff, specifically about the data used for training and the extent to which that itself needs to be disclosed in some way, sort of maybe similar to the way in software you would disclose source code or something. But his question is, for enablement, to what extent does the particular data used for the training make reproducibility a challenge?
That's a fantastic question. We have to, of course, if part of the claim invention is to train the machine learning using a certain type of data, you have to provide examples of that data to enable it. So we have in patents that we have filed, we have provided examples of what types of data have been used. Whether, for instance, this could be a classifier to diagnose lung cancer, and you have to say, well, you get this data set came from this type of tumor. This data set came from this type of tumor, to provide the breadcrumbs for the person of skill in the art to actually do that. So yes, fantastic question.
I have another question from Richard Warburg around sort of the possession part of written description. We can talk about, now that we know that these are two separate requirements, enablement and written description, but what happens if you're working with an LLM or a model and you have gone through iterations of training, but you still don't really know how it works? It's still a black box to you. Do you have a possession of it in terms of written description?
Yeah, that's a fantastic question. And it does come down to what's being claimed. So if the claim is around using machine learning as a black box and then outputting something, and as long as we have, of course, this is going to the flip side of the coin on the 112, which is enablement. But as long as we have enabled use of the ML, you don't have to show how it works. And I've never had issues come up because of that. Not to say that it won't happen, but you're not claiming the actual ML itself. On the flip side, of course, if the claim is around the actual ML, it's happening, it's got certain nodes or a particular node architecture. There are many flavors out there now. But if there's some special type of ML, you have to describe how it works and what it is to meet that threshold. And if you don't know, then of course there could be a potential issue of, well, did you really know enough to be able to patent it? And of course, I can see that being a problem downstream as well, because there are machine learning models out there that, frankly, are not understood how they operate, and this could become a bigger problem downstream. Great questions. Just to continue, this is my last slide here. Divided infringement, of course, we have to be cautious about that. I see this frequently, on the life science side, specifically for diagnostics. We are increasingly appealing to Vanda to put in a treating step tied to the JE to get past Section 101. From my standpoint, that doesn't raise any issues because usually the doctor that is ordering the test is also the one who is prescribing the treatment. So right now, that is not an issue from my standpoint, and it has not chilled innovation, hasn't chilled companies filing patents. And then, of course, when the ML is being applied, thinking about the actors that are involved. So we want to avoid having claims that cover both the method of training it and the method of using it, because sometimes those may be different actors. And so we want to be cautious about that. And I've talked about the treating. And of course, lastly is, which has been touched on before, which is that if the machine learning is the inventor, we have to be cautious about that, because right now they can't be inventors. And so I've been advising my clients to put in something that's been contributed by a human. So if the ML outputs a therapeutic, add in a formulation, add in this side group that works, and so on, just so that there is a human inventor involved as well. And
Great.
that's it.
Well, thank you so much, Ali. We really appreciate that very useful background. So it's such an honor for whatever I get to say it, and that it's true that Rob Murdris and Yuan, Dr. Howe are my colleagues. I'm going to now turn it over to Rob to give some commentary on what he's heard so far and the issues he's engaged in beyond inventorship.
Yeah, I think these are really, right now today, probably some of the most interesting issues, and probably the ones the PTO has to grapple with, right away. Just a couple observations on what the other speakers said. Really excellent presentations. It seems like part of the business of patent strategy, of course, is to start with your client's business model. And when I hear the discussion so far, it seems like there are two fundamental business models that might pose different sets of problems for the non-inventorship doctrines in patent law. The general purpose or sort of service bureau model, where you are building a fabulous platform that has a very high level of general capabilities. That's obviously a model where you want people to bring specific problems or problem areas to you, and then you kind of take this big, powerful machine and you turn it on it. And then at some point when you have something valuable, you throw it back over the fence to the person who commissioned you to turn your machine on their problem, right? It seems there's going to be a temptation in that business model to keep as much a trade secret as you can. That's your secret sauce. And with each client that you deal with, you're probably tweaking your model and optimizing it so that there could be increasing returns, where if you get an early lead in that service model or that general problem solver model, the sort of, come to Watson and he'll help you with your problem, that might reinforce the trade secret protection model. And, we've talked about it. Dennis mentioned it. Is that good or bad? Depends a little on, how much the public versions of AI software are keeping up with the proprietary developments. We could see a pattern similar to, let's say, the origin of open source software, where somebody says, hey, this proprietary model isn't good for me, for my business model, and I'm going to help encourage and maybe support an open source alternative to a proprietary, AI service model. So we might see that kind of interaction with the general service sort of approach. We could also imagine, it's possible, that if we feel that the proprietary software system owners have kind of a natural advantage, where we're seeing a concentration of expertise, maybe a concentration of economic power, there could be, a movement that, we see in several sectors. Think of the old Microsoft case or Amazon today, where some public resources, either on enforcement or duplication of the infrastructure, are encouraged to even the playing field and to break the cycle of the increasing returns. I think that will be especially true if general service AI companies are also claiming, patent ownership in some cases, because there you might have just sort of like an invention machine, and it just keeps rolling up new ideas, and you just keep patenting them. And the more you learn about solving problems, the more patents you get. The more patents you have to license, the better your model is, and you get this kind of over concentration problem. That's possible. The other business model is I think more common in the biotech space, where you might be optimizing a general system, but your general approach is, I want to train this on a very specific problem. I'm working in a vertical field, and I want to use these capabilities to help me. And there it seems the conundrum is going to be the one Ali mentioned. Peter alluded to it too, which is the tension between respecting maybe a non-disclosure agreement you had to sign with an AI service provider and your need to comply with 112. And we've seen that in other cases. If you're old enough to remember when the best mode requirement was really a requirement, there used to be cases once in a while where the best mode was protected as a trade secret by a third party. And so you had to kind of choose between breaching your confidentiality agreement for your input supplier, who is giving the best mode for pursuing your invention, versus your full disclosure requirement. And that can be a push and pull situation. As I think about the service bureau model, a point from the last session comes to my mind, which is kind of apropos Dennis's proposal. Maybe if inventorship is problematic, the solution, if you run a general AI solution shop, if that's your business model, bring your problem to me, I'll turn the machine on it and we'll give you help. If that's your business model, you could conceivably get some reach through royalties. You could conceivably have a claim contractually on the output of your system and the ways that it helps your clients. You wouldn't need to be named as an inventor. You wouldn't need to have a property right. If you can just say, anything developed using our facility, I'm going to get X%. And then we have all the problems of biotech reach throughs and those issues. But it could solve the problem of getting a share of compensation attributable to your technology without getting into inventorship issues, without having to be named, as an actual owner. So that's occurred to me. In terms of the doctrine, I saw some questions.
And also, I do want to invite people to, just given how late we are in the day, to make it interactive. If you do have comments that you want to make, I'll make one, just a question. I think it was super interesting to think about traditional patenting strategies and defensive patenting, right? And defensive publication. I mean, in some sense, making the model open source that as a competitive move is really interesting to think about. So, I mean, I don't know if you're concerned about sort of, I think one vision you've talked about is like a lot of rush to patenting. If you think that will be part of what Dr. Howe alluded to earlier, sort of on the technical side in terms of there being barriers to entry that you might be concerned about.
Well, I think right now it's a theoretical concern because it depends on so many variables. We don't have answers yet, but if you construct a conditional with enough parts to it, you can get to something that looks scary. If a big bureau, does claim inventorship, and if they get co-ownership of a lot of patents, and if they start to build this mega portfolio with the assistance of their technology, and if they get better and better at it, and their portfolio gets bigger and bigger, we could have a problem of just over-concentration, just that a huge number of AI-assisted inventions are owned by only a couple of AI facility companies. That would be a concern. And, there are various interventions we could suggest to deal with that. But I think that might be one that requires a lot of things to happen, though, for that problem to really materialize. As you've all said, I don't think we're there yet. I think the rush to patenting right now is just going to create the normal early technology, bottleneck at the PTO. It may look like .com 2.0 or where are we now, 3.0, whatever, where we just have this giant wave of applications and kind of sorting through who has priority to what piece of it becomes this kind of monstrous problem. I just want to say two more things and then back to the general. So one is the difference between prior art references, which AI is capable of producing, and the FOSITA, the level of skill in the art, because AI algorithms can contribute to both. So Peter reviewed the, I think, still purely speculative problem of a prior art machine that just sits there day and night generating prior art. I've never seen that as a realistic set of issues, partly for the enablement problem that you mentioned, Peter, and partly just because under inherency doctrine, somebody somewhere has to understand it. Theoretical prior art is a little bit like that little particle in the Seaborg case. Yeah, if you run the reactor for 3 days, you get a couple trace, atoms of this new element, but nobody can see it, get it, or appreciate it. So it's sort of like the Library of Babel, where it exists theoretically, but nobody can find it on the shelf. So it's not really prior art, really. So I consider that an issue. But related, and I wonder if anybody's given this any thought, it seems like search has put some pressure on the old doctrine of analogous arts, because analogous arts imagines a world where we search subject matter fields vertically, right? We say either it's in the same field or it would be naturally looked at to solve a given problem. It seems like, the analogous arts doctrine may be under significant pressure in the AI world because it's so good at searching laterally. It's so good at finding obscure things that couldn't be found without its help. And that to me suggests that maybe the second prong of analogous arts, it would be relevant to solving the problem, is about to get really big. Because if an algorithm is trained to look broadly enough, then you might have odd situations where some problem in chemistry really is helped by a piece of prior art that was, in the auto repair field, or that was in, some unrelated field. And only a super robust AI-assisted search engine would have even noticed that discussion, which uses synonyms from an outside field, so on and so forth, is really related to your problem. So Google has flattened the world for analogous arts. AI might flatten it further, and we might get to the point where we say almost everything is relevant because of these super search capabilities. And I've wondered about the future of that doctrine. So the FOSITA as a skill level versus references, that's a topic that comes up a lot in our course. Getting students to understand the difference between a level of skill, which is the cognitive abilities you bring to the prior art, versus the actual references in the prior art. And I think AI is much more about the skill level than it is about creating a library of, semi-fictional references. That's what I think about that. Anyway, enough.
Thank you so much. I'm going to transition to Dr. Howe, but I want to address or pose a couple questions in the chat and then ask any panelist who wants to take them to address them. So one is about this question around formulations. I think this might be for Ali. If you claim the formulation, and this is from Richard Warburg, I believe, and the AI is prior art, do you disclose this information in a prior art statement? So anybody who wants to take that.
If the AI is prior art against the formulation, if the AI itself, if it's not public, then if it's not publicly disclosed, if you're keeping it as a black box that you are using yourself to output a therapeutic target or a therapeutic, it wouldn't be prior art because it's not publicly known. Now, and this actually goes to the reason why I tell my clients, do not use ChatGPT, please. That could raise issues that smart people on this call can figure out, which is what is the prior art effect there if you were to go onto ChatGPT and come up with some sort of compound, and then is that prior art? And that hasn't yet been tested.
Yeah, that we could have a whole conference on ChatGPT and what its implications are for creativity. But I have another question from Alan Minsk about this is a question from Matthew Boxer about the risks that come with sort of the innovation being really in the data itself. So for anybody who wants to answer this question, in our computer age, if we store our ML, AI, or training data as trade secret on the internet, but we might lose them to hackers, like what is the concern there? Is there the potential to really lose your trade secrets just because everything's in the cloud? There's no way to store all this data by itself and everything that comes with it. If anybody has any thoughts on that one. Okay, well, let's go ahead and turn to Dr. Howe and get her thoughts on the things that she's most worried about or interested in. keep it positive in terms of issues beyond inventorship.
Thank you, Professor Chien. So I'm gonna share my screen. So again, heard a lot of fascinating points, and I myself have a lot of comments and questions, but I guess I don't have enough time, so I'll make my own point first. So can you see the screen?
Yes, and don't feel free to comment. I think that we want it to be interactive. So if you want to make any points on what's already been discussed, please take it. We're fine.
Yeah, I'll try to make it during. I mean, I only have maybe 5 minutes. So
yeah, yes. Take your full 10. We're fine. We're gonna.
I thought we're gonna end by 55, right? So
I think we have till 4. It's okay. Yeah.
Oh, okay, good. Good to know. So this is just to put my own point in sort of in a perspective. Professor Murgis and me, we are at the very early stage of co-authoring a paper on non-obviousness. But we provided this three-bodied framework for our students to think about the challenge to non-obviousness in class. Professor Murgis, he briefly talked about the AI impact on the skill level of OCEDA, as well as the scope and content of analogous art. So I'm going to focus on a third factor here, particularly the human being's role in a loop, and non-obviousness as embodied in the problem finding and framing part. So So as I explained in the previous panels, so without drastic changes to the underlying AI models, these two steps will largely still remain human beings' unique role for a decent period of time. So on this topic, I just want to quote Professor Laura Farina, because in my mind, she really made great contribution to patent law from the perspective of sociology. So in a groundbreaking paper in 2017, Professor Farina argued that conventional patent law doctrines is out of step with how scientific and technical research actually take place in a lab. And problem finding and problem framing are key rate limiting steps in the formulation of breakthrough ideas and steps that deserve more attention from a law and policy perspective. Professor Farina talked about in a non-AI context, but I found it very helpful to apply this to the AI context. But while I agree with her strongly about the importance of problem finding and framing, it seems to me that US case law has not completely ignored this. For instance, in its 2008 Federal Circuit case, in re Alemozafar patent litigation, the Federal Circuit affirmed the lower court's holding that the claimed invention, which is to add this anteric subcoating to the omeprazole preparation process to increase the storage stability and prevent the drug from degrading in the stomach, was non-obvious, because even though similar subcoatings for anteric drug formulation was disclosed in prior art, none of the references ever suggested a negative correlation between the anteric coating and the drug. Therefore, in other words, the specific problem with the prior art formulations has never been recognized. And so there would have been no reason to the first place to seek improvement. And according to the USPTO's interpretation, this case can also be analyzed in the view of the discovery of a previously unknown problem by the patentee. So if the adverse interaction between active agent and coating had been known, it might as well have been obvious to use a subcoating. However, since the problem had not been previously known, there would have been no reason to incur additional time and expense to add another layer. Even though addition would have been technologically possible, So this is true because the prior art of record failed to mention any stability problem, despite the acknowledgement during testimony at trial that there was a known theoretical reason that this drug might be subject to degradation in the presence of the known coating material. So just a few thoughts and policy suggestions on this on my own. So in the first place, I don't believe everything will be obvious in this dawning AI-assisted age. One big reason is that the human creativity part, this inventive problem finding and problem framing, no matter inventive process or artistic creation process for copyright law's sake, will remain largely challenging and interesting for a decent period of time. And hopefully forever so, in my opinion, simply because to invent and create is such an essential part of us being human, as I mentioned this in a previous panel. So as a policy suggestion, patent law should pay much more attention to the non-obviousness as embodied in these two steps, problem finding and framing, which will largely stay a place for the human beings. So, and also this suggestion, I think, is in harmony with my previous proposal of constructive conception, which helps to qualify human researchers that found and framed a non-obvious problem as inventors. And the last point I want to make is that facing the various challenges, we talked about some of them today, the AI-assisted inventing or creative process poses the IP system, we should really have a holistic approach to address these challenges with the eventual purpose of promoting human creativity rather than displacing it. So that's just a few slides. Thank you.